scholars. The Dean has chosen to speak to us on a Supreme Court in transition. As a reminder to all, please use the Q&A at the bottom of your Zoom screen to send in your questions. Welcome, Dean Chemerinsky.
Thank you so much for the kind introduction. Speaking to the Plato Society is special for me, and I look forward to the opportunity to come in person again. But I'm glad that there's the chance to talk via Zoom. It is an amazing time to talk about the United States Supreme Court. I want to offer some words by way of overview, then illustrate with some important cases from last year of the Supreme Court, and then talk about what's on the docket for this term. The oral arguments will begin, as always, on the first Monday in October, October 4th. In terms of some general thoughts about the court, I think the most important change in recent times occurred on Friday, September 18th, 2020, almost exactly a year ago, when Justice Ruth Bader Ginsburg died. On Monday, October 26th, Justice Amy Coney Barrett was sworn in. This is a crucial transition with regard to the court. It's often been said that every time there's a new justice, it's a different court. We've had 3 new justices in just the last 3 years. When we think about Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, all appointed by President Donald Trump. I neither want to overstate the significance of the transition from Ginsburg to Barrett, nor underestimate its importance. I think a statistic that's particularly revealing here comes from Justice Ginsburg's last term on the Supreme Court, October term 2019, as it's commonly referred to. Every term of the Supreme Court is referred to by the October when it begins. On October 4th, we're going to begin October term 2021. In Justice Ginsburg's last term on the Supreme Court, the court decided 53 cases with signed opinions after briefing and oral argument. That was the fewest number decided in a year since 1862. Of those 53 cases, 14 were 5-4 decisions. In 10 of the 14, the majority was Roberts, Thomas, Alito, Gorsuch, and Kavanaugh. Had Barrett been on the court instead of Ginsburg, those probably would have been 6-3 rather than 5-4 cases. Everything we know about Amy Coney Barrett is that she's likely to be a very conservative jurist. Her writings as a Notre Dame law professor, her time as a federal court of appeals judge, her short months on the Supreme Court all suggest her being the far right of the Supreme Court bench. She's among the more conservative judges in the United States, which is why President Trump nominated her. So had she been on the court in those cases, she would have been with the 5-person majority, making it 6-3, changing the margin, but not the outcome. But that year, Justice Ginsburg's last on the court, there were 2 5-4 decisions where the majority was Roberts, Ginsburg, Breyer, Sotomayor, and Kagan. They were important cases. One struck down a Louisiana law imposing restrictions on abortion. The other said that President Trump had not lawfully rescinded DACA, the Deferred Action for Child Arrival program. Had Barrett been on the court rather than Ginsburg, these 2 cases would have come out differently. In fact, over the last decade, there have been some very important instances where there were 5-4 decisions with Roberts joining Ginsburg, Breyer, Sotomayor, and Kagan. The Supreme Court's decision in 2012, upholding the Affordable Care Act, was 5-4 with Roberts joined by Ginsburg, Breyer, Sotomayor, and Kagan. So when Barrett replaced Ginsburg on the Supreme Court, I made 2 predictions. One was we would see a lot more 6-3 decisions. There are now 6 justices appointed by Republican presidents and 3 by Democratic presidents. The other prediction is we would see a lot fewer, maybe hardly any, 5-4 decisions where the liberal justices win the majority. Simple arithmetic explains why. In order to get a majority, the liberal justice would need to attract 2 votes, not just 1, and 2 from a court that has 5 staunch conservatives in Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, and 1 moderate conservative in Roberts. The statistics from last year bear out my prediction. Last term, October term 2020, the Supreme Court decided 54 cases with signed opinions after brief oral argument. It would be the fewest number since 1862, except for the year before where the court decided 1 less. Of those 54 cases, 12 were 6-3 decisions and 6 were 5-4 decisions. Some of the most important rulings of the year, including some that I'll talk about, were 6-3 decisions. And there was no case where the liberal just won the majority in a 5-4 ruling. As we look ahead to this year, October term 2021, those would be my predictions. We're going to see a lot of 6-3 cases, and it's unlikely we're going to see many where the court's ideologically divided, where Breyer, Sotomayor, and Kagan will be in the majority. The reality is, this is the most conservative Supreme Court that there's been since the 1930s. And it's likely to stay that way for some time to come. Think of the ages of the conservative justices. Amy Coney Barrett was 48 years old when she was sworn in last October 26th. If she stays on the court until she's 87, the age which Justice Ginsburg died, Barrett will be a Supreme Court justice into the year 2059. Gorsuch was 53, Kavanaugh 55, Roberts 65, Alito 70, and Thomas 72. I've long thought that one of the best predictors of a long lifespan is being confirmed for a seat on the Supreme Court. After all, Justice Stevens didn't retire until he was 90 years old. So I think we're likely to have this conservative majority for another decade or 2. Well, let me talk about last term of the Supreme Court and then focus on what's on the docket this term, and then leave plenty of time for your questions. Titled this talk, The Supreme Court in Transition, and in focusing on last term, I want to discuss 2 areas that reflect this transition. One concerns the Supreme Court and religion. There are 2 provisions in the First Amendment that deal with religious freedom. One says that there can be no laws respecting the establishment of religion. And the other says the government cannot abridge free exercise of religion. We are seeing a dramatic shift on the Supreme Court as to both of these constitutional provisions. With regard to the Establishment Clause, for decades, a majority of the court said it was best understood through a metaphor coined by Thomas Jefferson, that there should be a wall that separates church and state. Now, though, 6 of the 9 justices reject the idea of any walls separating church and state. They believe we should accommodate religion into government and government support of religion. They believe that the government violates the Establishment Clause only if it literally establishes a church or coerces religious participation. So for them, religious symbols on government property don't violate the Constitution. For them, prayer, government activities doesn't violate the Constitution. As we'll see, for them, government aid to religious schools doesn't violate the Constitution, but denying it infringes free exercise of religion. The other provision is the Free Exercise Clause. And what we've seen is a conservative majority that wants to aggressively protect free exercise of religion, even if it means creating exceptions from other laws, including anti-discrimination laws. Well, let me talk about last term with regard to religion. And I want to talk about 2 areas. The first concerns religious challenges to governors' closure orders try to limit the spread of COVID. Here, we truly do see a court in transition. Governors around the country have imposed many restrictions trying to limit the spread of COVID. There have been 4 matters that have come to the Supreme Court about this. The first of them was in May of 2020. It was South Bay Pentecostal Church versus Newsom. Governor Gavin Newsom, as part of his closure order, said there couldn't be more than 25% usual capacity or 100 people at any religious gathering. South Bay Pentecostal Church in Southern California, in the South Bay, brought a challenge to this. It sought an injunction to allow it to have larger attendance at religious worship services. The federal district court denied the injunction. The United States Court of Appeals for the Ninth Circuit denied the injunction, and they went to the Supreme Court for an injunction. This was on the Supreme Court's so-called shadow docket. You might see mention in the news about the shadow docket. All that means is matters that come to the court for an emergency injunction or an emergency lifting of an injunction. And there's not full briefing and oral argument. Well, the justices 5-4 ruled against South Bay Pentecostal Church. Chief Justice Roberts, joined by Justice Ginsburg, Brierson, and Kagan, were the majority. There was no opinion for the court, but Chief Justice Roberts wrote an opinion for himself. He said there needs to be great deference to the government to stop the spread of communicable disease. Said the court should leave it to experts in public health to decide what's appropriate. Justice Kavanaugh wrote the dissent. Justice Thomas, Alito, and Gorsuch all dissented. And Justice Kavanaugh said that this is discriminating against religion. It should be unconstitutional. 2 months later, in July 2020, similar matter came to the Supreme Court. It was Calvary Chapel, Dayton Valley versus Sisolak. Governor of Nevada, Steve Sisolak, imposed restrictions to try to stop the spread of COVID. A church brought a challenge to this, saying it violated the free exercise of religion. The federal district court denied an injunction. The United States Court of Appeals denied an injunction and went to the Supreme Court. And the Supreme Court, 5-4, denied the injunction, ruled against the church, and in favor of the governor's order. The 5 in the majority, once more, were Roberts, Ginsburg, Brierson, and Kagan. None of them wrote an opinion. Justice Alito wrote an angry, sarcastic dissent, saying this is discriminating against religion. And he was joined by Justice Thomas, Gorsuch, and Kavanaugh. 4 months later, on November 25th, the court issued a ruling in Catholic Archdiocese of Brooklyn versus Cuomo. The court's ruling came down on the night before Thanksgiving, a few minutes before midnight. What was involved here is then New York Governor Andrew Cuomo imposed restrictions. The restrictions vary depending on the prevalence of COVID in an area. Where COVID was most prevalent was the red zone. In the red zone, no more than 10 people could gather for religious worship. In the area where COVID was next most prevalent was the orange zone. No more than 25 people could gather for religious worship. Some Catholic churches in Brooklyn and some Orthodox Jewish synagogues brought a challenge. They sought an injunction. The federal district court ruled against them. The United States Court of Appeals for the Second Circuit ruled against them. But the Supreme Court reversed 5-4. It was an opinion of all of the justices, no single justice wrote it. It's called a per curiam opinion of the court. But the 5 in the majority to overturn this were Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. And they said that it was impermissible discrimination against religion because New York was allowing bike shops to open in these areas, but restricting gatherings for religious worship. The court said that there can't be discrimination against religion, even in a pandemic. Chief Justice Roberts wrote a dissent. Justice Breyer wrote a dissent joined by Justice Kagan, and Justice Sotomayor wrote a dissent joined by Justice Kagan. Justice Sotomayor said, there's no discrimination against religion here. She said, equality means treating likes alike and unalikes unalike. She said, a bike shop isn't like a church in terms of the chances of spreading COVID. She said, regulation should be upheld. The final case in this sequence was Tandon versus Newsom, first Friday night in April of this year. It involves another part of Governor Gavin Newsom's restrictions. It said there could not be 3 households of people who gather at the same time in a home, no matter what their purpose. You can't have more than 3 households. If the goal was watching the Super Bowl, you can't have more than 3 households. The reason is prayer. And this was trying to stop, obviously, the dissemination of the virus, stop the spread of a communicable disease. Some individuals who wanted to have larger gatherings in their home for religious purpose brought a challenge. They wanted an injunction. The federal district court ruled against them. The United States Court of Appeals ruled against them, and they went to the Supreme Court. And the Supreme Court ruled in their favor. It was 5-4. 5 in the majority: Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Here, Justice Kagan wrote the dissent, joined by the other justices. The opinion of the court said, religion must be treated as favorably as the most leniently regulated secular activity. The court said that for the government to allow secular activities but restrict gatherings for religious worship is a violation of free exercise of religion. Justice Kagan said this doesn't discriminate against religion. Justice Kagan says no gatherings of more than 3 households, whatever the reason that people are getting together. Also, Justice Kagan said gathering for religious worship isn't the same as getting together in a bike shop. People are likely to stay longer if they're there for religious worship. They're more likely to engage in activities like chanting and singing that could spread the virus. There's likely better ventilation in a store than in somebody's home. But the Supreme Court has made clear, as I said to my students, that religion has most favored nation status. The court said religion must be treated the same as all italicized comparable secular activities. I think these cases show you a Supreme Court in transition. The first 2 cases, Justice Ginsburg was on the bench, came down on the side of the governors against religion. But with Justice Barrett replacing her, they came down exactly the other way. The other case from last term that I'll talk about with regard to religion was Fulton versus City of Philadelphia. Philadelphia, Pennsylvania, relies on private social service agencies to place children in foster care. The city insists that the private social service agency agree to not discriminate based on race, sex, religion, or sexual orientation. Catholic Social Services brought a challenge to this. They said because of their religious beliefs, they could not place children with same-sex couples. They brought a challenge to the Philadelphia requirement. The federal district court ruled in favor of the city of Philadelphia and against Catholic Social Services. The Federal Court of Appeals, the United States Court of Appeals for the Third Circuit, ruled in favor of Philadelphia and against Catholic Social Services. These courts relied very much on an earlier Supreme Court decision from 1990, Employment Division versus Smith. Employment Division versus Smith involved an Oregon law that prohibited consumption of peyote. Native Americans brought a challenge and said that their religious rituals required the use of peyote. They said to deny them this, to punish them for peyote, infringed free exercise of religion. The Supreme Court, in an opinion by Justice Scalia, ruled against the Native Americans. Justice Scalia, who's conservative justice ever to serve on the Supreme Court, said, we don't give exceptions to general laws on account of religious beliefs. He said, so long as the law is not motivated by a desire to interfere with religion, and so long as it applies to everyone, you can't use free exercise to challenge it. He said, this is important in a society that's as diverse as ours with regard to religious beliefs. Also, he said, if we're going to give an exception to laws for religion, we're going to have to define what's a religion. We're going to figure out what's a sincerely held religious belief. And so the court said, it's a general law not motivated by desire to interfere with religion. No exceptions. Well, in Fulton versus City of Philadelphia, the federal trial court and the Court of Appeals both said the Philadelphia anti-discrimination requirement is not motivated by desire to interfere with religion. It applies to everyone, no religious exception. The United States Supreme Court reversed. Chief Justice Roberts wrote for the court. He said, the Philadelphia ordinance gives city officials the discretion to grant exceptions. Now, it turns out no exception ever has been granted under the ordinance. City officials say they had no intent to ever give an exception. But the Supreme Court said, so long as there is the possibility of an exception, then this law that burdens religion is unconstitutional unless it serves interests of the highest magnitude and there's no other way to achieve it. So any law that gives government officials any discretion that burdens religion likely violates free exercise. Here, Justice Alito wrote an opinion concurring in the judgment, joined by Justice Thomas and Gorsuch. He said, let's overrule Employment Division versus Smith and do it right now. Justice Barrett wrote a concurring opinion, joined in full by Justice Kavanaugh, which she said, we don't need to reach that question, whether to overrule Smith today. We can just rule in favor of Catholic social services. But she said, I agree with Justice Alito. I find his reasoning more persuasive. I think that this case shows that there are likely 5 votes on the Supreme Court to overrule Employment Division versus Smith. Thomas, Alito, Gorsuch, and then Barrett and Kavanaugh. Well, what would this mean? Why does it matter? There are many cases on their way to the Supreme Court that involve bakers or florists or videographers who don't want to serve same-sex weddings, even when there's state laws that prohibit discrimination based on sexual orientation. Or as another example of this, a year ago, the Supreme Court said that federal law prohibits employment discrimination based on sexual orientation or gender identity. There are now many cases pending of employers who claim a right to discriminate on account of their religious beliefs against gay, lesbian, transgender individuals. I think that what we're going to have is a majority on the Supreme Court likely to rule in favor of those who want to discriminate on the basis of free exercise of religion. Let me put it to you another way. There is always a tension between liberty and equality. Any law that prohibits discrimination limits a freedom to discriminate. But our society has made the choice for over a half century that stopping discrimination is more important than protecting freedom to discriminate. Now, though, I think we have a majority on the court that's going to take the position that free exercise of religion protects the right to discriminate. The other area I want to talk about from last term concerns voting rights. And the case is Brnovich versus Democratic National Committee. It was decided July 1st of this year. I think that the Voting Rights Act of 1965 is one of the most important federal laws adopted in my lifetime. It did 2 primary things. First, it said jurisdictions with a history of race discrimination in voting needed to get pre-approval, called pre-clearance, before significant change in their election system. So this applied to 9 states, almost all in the South, to many local governments. Given their proven history of race discrimination voting, to change it, they would need to get permission, pre-clearance from the Attorney General or federal court in Washington, D.C. We know that the requirement for pre-clearance blocked hundreds of discriminatory voting laws from going into effect, and hundreds, maybe thousands more, that never were adopted because of no knowledge that there was a need for pre-clearance. In June 2013, in Shelby County versus Holder, the Supreme Court declared unconstitutional the key provisions that required preclearance. No longer is any state or any city required to do this. The result was, as soon as the Supreme Court in Shelby County struck down the Voting Rights Act, states like Texas and North Carolina immediately put into effect the very laws where preclearance had been denied. Statistics now show that since 2013, there's been a statistically significant decrease in voting by individuals of color. And this was predictable from striking down this crucial provision of the Voting Rights Act. Chief Justice Roberts wrote the opinion. It was 5-4. And Chief Justice Roberts, in his opinion, offered everyone reassurance. He said, we don't need to worry so much that the preclearance requirement is struck down, because there's still another provision of the Voting Rights Act that will protect access to the polls and voting. And that's Section 2 of the Voting Rights Act. It prohibits state and local governments from election systems that discriminate on the basis of race. In 1982, Congress amended Section 2 to say that there's a violation if there's proof that an election practice has a racially discriminatory effect against minority voters. Brnovich versus Democratic National Committee involves two provisions of Arizona law with regard to voting. One of the provisions said a vote would be counted only if it was cast in a person's own precinct. It wouldn't be counted if it was cast anywhere else. The other provision said that an absentee ballot had to be turned in by the person who cast it or a family member of that person. Nobody else could turn it in, prohibiting so-called ballot harvesting. The United States Court of Appeals, the Ninth Circuit, in an en banc decision on behalf of 11 judges, found that these provisions violated the Voting Rights Act. In an opinion by Judge William Fletcher, the Ninth Circuit explained how each of these provisions had a discriminatory effect against minority voting. For example, with regard to the requirement of voting within your precinct, statistics showed that they moved the polling places much more in Black and Latinx communities than in white communities. With regard to the restrictions on ballot harvesting, it was pointed out that on many Native American reservations, there's irregular, or even worse, mail service, and thus the need for others to turn in the ballot. On Thursday, July 1st, the Supreme Court, in a 6-3 decision, reversed the Ninth Circuit. Here, Justice Alito wrote for the court, joined by Roberts, Thomas, Gorsuch, Kavanaugh, and Barrett. Justice Kagan wrote a vehement dissent, joined by Justice Breyer and Sotomayor. Justice Alito said that whether there's a violation of Title II is to be determined based on the totality of the circumstances. He said, we're going to give guidance to the lower courts. Here's 5 things they should consider. And it's interesting that all 5 will make it much more difficult to prove voting discrimination. He said, first, we should look at the extent of the burden on voting. He said, all regulation will have some burden. It has to be a very significant burden to violate the statute. Second, he says, we have to compare the restrictions to what existed in 1982 when Congress amended the law. He said, if there were much worse restrictions then, we shouldn't be so troubled by these restrictions. He said, we should look at the extent of a discriminatory effect against minority voters. He said, it has to be a very significant discriminatory effect. So we live in a society where there's inequalities based on wealth and education that correlate to race. So the fact that there's some discriminatory effect against minority voters doesn't matter. He said, fourth, we have to look at what are the other ways of voting in the state. The more there's other ways that people can go and vote, the less there's reason to be concerned about any particular restriction. And fifth and finally said, we have to look at the state's interest that's involved. And the state's interest is in preventing fraud. He said, when you look at all of these 5 considerations, the Arizona law is permissible. It doesn't violate the Voting Rights Act. Justice Kagan wrote a blistering dissent. To start with, she said, none of these 5 considerations anywhere are in the law. She said the law was meant to broadly protect the right to vote. Congress said you don't have to prove a discriminatory intent. Showing a disparate impact is enough, but the majority rejects that. Justice Kagan said many states are adopting laws that are restrictive with regard to voting. At that time, there'd been laws in places like Georgia and Florida. Since then, we've seen Texas do the same. And she says that this decision is going to make it very difficult to bring successful challenges to these laws. Unquestionably, Justice Kagan is correct. The Supreme Court has certainly increased the obstacles, not just gutting Section 2 of the Voting Rights Act. It is going to be very difficult in light of the Supreme Court's decision to bring challenges to the Georgia, the Florida, the Arkansas, the Texas, with the laws adopted altogether in 18 states restricting the right to vote. There are 2 different narratives about voting in the United States. They very much correspond to one's political party. The Republican narrative is that there is significant voter fraud and that the government must be able to act to deal with it. And that's what the Arizona law, or the ones in Georgia, Texas, Florida, purport to be about. The other narrative says that the real problem with regard to voting is disenfranchisement of minority voters. That voting fraud isn't proven, and it's certainly quite limited. The former narrative, which focuses on fraud, is adopted by Republicans. The latter narrative, which focuses on equality of voting for people of color, is very much favored by Democrats. There are 6 Republican appointees on the Supreme Court and 3 Democratic appointees. So should any of us be surprised that the court 6-3 upheld this very narrow interpretation of the Voting Rights Act? There's going to be huge consequences from it when we get to the 2022 or 2024 elections. So now let me shift and talk about this term of the court. As I said, it will begin on Monday, October 4th, the first Monday in October. I titled my talk today, The Supreme Court in Transition. If you're kind enough to invite me back next fall, I think I'll title it The Supreme Court, a Blockbuster Year. I think this is going to be an exceptionally important term in the Supreme Court. Let me pick 3 areas that are already before the Supreme Court. And just as background, the Supreme Court grants review in about half of its docket before they go on recess in June. They'll come back next week and they'll begin taking additional cases, and they'll continue to take cases to be heard this year until the middle of January. After that, anything they take will be heard next year. So we know of about half the docket already. And wow. Let me talk about 3 areas. The first is abortion rights. The case that's on the Supreme Court's docket is Dobbs versus Jackson Women's Health. It involves a Mississippi law that prohibits abortions after the 15th week of pregnancy. In 1973, in Roe versus Wade, the Supreme Court held that states cannot prohibit abortions prior to viability, the time at which the fetus can survive outside the womb. In 1992, in Planned Parenthood versus Casey, the Supreme Court said it was reaffirming the essential holding of Roe versus Wade, that states cannot prohibit abortions before viability. Science and medicine tells us that viability is generally the 24th, maybe the 23rd week of pregnancy. But the Mississippi law would clearly prohibit pre-viability abortions. The Supreme Court granted review on one question: may states prohibit abortions before viability? Prior to this case, There were many states that adopted laws that tried to prohibit abortions before viability. Some did so at the 20th week of pregnancy, some like this at the 15th week, some even earlier. The Supreme Court denied review in all of those cases after they've been struck down by the lower courts. Here, the lower courts struck down the Mississippi law, but the Supreme Court granted review. For those who believe in abortion rights, the Supreme Court choosing to take this case is an ominous sign. But there's another ominous sign from just 3 weeks ago. And this is a case called Whole Women's Health versus Jackson. Texas adopted a law prohibiting abortion once the fetal heartbeat can be detected. Actually, it's not the fetal heartbeat, it's electrical activity fetus. And that's about the 6th week of pregnancy. And Texas says the law will be enforced not by its prosecutors, but instead by civil suits. A doctor or health professional who performs an abortion or aids and abets with an abortion is liable for $10,000 in damages. Texas says, you can't sue us, you can't sue our officers, because we don't play any role in enforcement. The federal district court said, this is a state law. It violates the Constitution. We're going to enjoin it. The United States Court of Appeals of the Fifth Circuit lifted the injunction. And on Wednesday night, September 1st, a little before midnight, Eastern time, the Supreme Court 5-4 said that it was going to deny review. It wasn't going to issue a preliminary injunction. It was requested to do that, but it refused. The 5 in the majority, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Chief Justice Roberts wrote a dissent. Justice Sotomayor wrote a blistering dissent. And these dissenting justices said is, Roe is the law. Roe says there's a right to abortion till the 24th week of pregnancy. This prohibits abortion at the 6th week of pregnancy, and it's clearly unconstitutional. I think that what you have here is, again, 5 justices, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, who want to overrule Roe versus Wade, and who don't want to block laws restricting abortion. I can't count to 5 justices who would be willing to reaffirm Roe versus Wade. I think that the Supreme Court is either going to explicitly overrule Roe or effectively overrule Roe. What will that mean in terms of women's lives? Well, it'll be up to each state to decide for itself its law with regard to abortion. Places like California, New York, Illinois will continue to allow abortions. But it's estimated that already over half the states have laws on the books that will prohibit abortions. And it's likely that between 25 and 30 states altogether will prohibit virtually all, if not all, abortions. For a woman in one of those states who has money, she can travel to a place where abortion is legal and safe. But for poor women, and especially for teenagers, they will go back to having the tragic choice between an unsafe back alley abortion and an unwanted child. So the case is Dobbs versus Jackson's Women's Health. It's going to be argued on December 1st of this year, and I expect a decision then in May or June. The second area that I talk about for the coming term concerns gun rights. And the case is New York Rifle and Pistol Association versus Brewer. From 1791, when the Second Amendment was adopted, until June of 2008, not one federal, state, or local law regulating guns was struck down by the Supreme Court. In the few Supreme Court cases about the Second Amendment, it said that it's about what it says, a right to have guns for the sake of militia service. But in June 2008, the court decided District of Columbia versus Heller. The court declared unconstitutional a 35-year-old DC ordinance that prohibited private ownership or possession of handguns. The Supreme Court's opinion was narrow in some senses. Justice Scalia wrote it, and he said, that the court was just saying there's a Second Amendment right to have guns in one's home for the sake of security. And the court said it's not an absolute right. The government can prohibit people with a felony conviction of having guns. The government keep guns out of places like airports and schools. The government can keep people having particularly dangerous guns, weapons, like a bazooka. But between June of 2008 and now, there's been no Supreme Court case but the scope of the Second Amendment. No case in terms of what the government can and can't regulate. That's what makes the New York law important. New York City has an ordinance that restricts the ability to have concealed weapons outside the home. The district court upheld the New York law. The United States Court of Appeals for the Second Circuit agreed and upheld the New York law, and the Supreme Court granted review. Here's the issue. Does the Second Amendment protect the right to have guns outside the home? With regard to the Second Amendment right, does it include a right to have concealed weapons outside the home? My sense is that there are 5 justices on the current court who much more want to aggressively protect gun rights, and this is the case where we're going to see it happen. Third case on the docket for next term that I want to talk about concerns religion in the First Amendment. It's something I addressed earlier in my remarks, but let me tell you about the case that's on the docket this term. It's Carson versus Macon. For much of Supreme Court history, certainly in the last half century, the issue has often been, when may the government give aid to religious schools without violating the Establishment Clause? There are many successful challenges to government aid to religious schools saying that it's an impermissible establishment of religion. But now the issue is, when must the government give aid to religious schools or it violates free exercise of religion? Let me make this less abstract. There have been cases for decades about whether the government violated the Establishment Clause. It give aid to religious schools for things like sign language interpreters or books or audiovisual equipment. And a large body of law developed in terms of what aid was allowed and what aid could easily be used in religious indoctrination violated the Establishment Clause. Now, though, the focus is, when is the government constitutionally required to give aid or it infringes free exercise of religion? There are a couple of Supreme Court cases that made this issue salient. In 2017, the court decided Trinity Lutheran versus Comer. The state of Missouri gave schools aid for playgrounds. If to create a soft substance so a child fell, the kid wouldn't be injured. The state said it would give this aid to any public school or any secular private school that qualified, but wouldn't give it to religious schools. There's a provision in the Missouri Constitution, like that in 43 states, that gives direct or indirect aid to religion. The Supreme Court declared this unconstitutional. Chief Justice Roberts wrote for the court. He said, for the government to give this aid to secular private schools, but not to religious schools, was an infringement of free exercise of religion. Justice Sotomayor wrote a dissent saying, this is the first time in history that the Supreme Court has ever required the government to give aid to religion. Now, Chief Justice Roberts, in his majority opinion, said this is just about aid to playgrounds. In footnote 3 of the opinion, says about aid to playgrounds and nothing else. But we know that's not how the Supreme Court operates. In June of 2020, the court decided Espinoza versus Montana Department of Revenue. The state of Montana adopted a law that gave people tax credits if they had money to private school tuition organizations. It was a small tax credit, up to $150. And someone could get the tax credit if it went to a private school, whether it was religious or a non-religious private school. The Montana Supreme Court found that this program violated the Montana state constitution. The Montana Supreme Court said the Montana Constitution forbids direct or indirect aid to religion. And the Montana Supreme Court said that virtually all the private schools in the state were religious. So this was subsidizing religion. I would have thought this would have been the end of the litigation. A state Supreme Court found a state law to violate the state constitution. But the Supreme Court, in a 5-4 decision, reversed. Chief Justice Roberts wrote the opinion for the court. Chief Justice Roberts said, whenever the government gives aid to secular private schools, it is constitutionally required to give the aid to religious schools, unless doing so would violate the Establishment Clause. And very little ever violates the Establishment Clause for these justices. So the government is constitutionally required to give religious schools the same thing as giving to secular schools. Well, that's the lead in to the case that's before the Supreme Court this year, Carson versus Macon. In Maine, in especially rural areas, there's not a public school system. There's a school administrative unit, and it provides funds to parents to send the children to a private school. The funds can be used for any secular private school. They can't be used for, quote, sectarian schools. Challenge brought on this by some religious schools that claim that to deny them the aid infringes the free exercise of religion. Now notice, the issue used to be, when may the government give aid? Would giving aid violate the Establishment Clause? Now the issue is the refusal to give aid a violation of free exercise of religion? And in light of where the court's been going, it would seem that the Supreme Court's very likely to say that the government can't deny this aid to religious schools. So those are 3 of the cases to be on the lookout for this term. At least at this stage for this term, there's no new justices. We'll have the same 9 justices on the bench that we've had since last October 26th. There's certainly lurking in the background the question, will Justice Stephen Breyer step down? Let President Biden pick a successor. But at least to now, Breyer is not, and that leads me to believe he's not going to retire, at least for this term. We'll see what happens at the end of the term, the end of June, beginning of July of 2022. It is a Supreme Court in transition. It is an amazing time in the United States Supreme Court. And I'm glad with that to take any questions.
Okay, thank you very much. We have a long list of questions, so I'm going to try and lump them together for those who may not hear their exact wording. But the one that shows up the most is, how do we go about, or is there a process to change the composition of the court? Do we do age limits? Do we do term limits? Do we expand the court? Could you speak on that issue for a moment?
Of course. There are processes, but they're very difficult and therefore quite unlikely. Let me go in reverse order of what you mentioned, expanding the size of the Supreme Court. The size of the Supreme Court is set by federal law, not by the Constitution. So Congress, just by adopting the federal law, could increase the size of the Supreme Court. The size of the Supreme Court is varied over the course of American history between 5 justices and 10 justices. 9 is just a historic accident. I think there's a strong argument for expanding the size of the Supreme Court to restore ideological balance. Did you know that between 1960 and 2020, there were 32 years with a Republican president and 28 years with a Democratic president? In 2024, it'll be exactly 32 and 32. But between 1960 and 2020, Republican presidents picked 15 Supreme Court justices. Democratic presidents picked just 8. I think expanding the size of the Supreme Court is the way to achieve ideological balance. But any bill to increase the size of the Supreme Court has to be passed by both the House and the Senate. We know to a certainty Senate Republicans would filibuster such a bill. It has no chance of getting through. What about term limits for Supreme Court justices? Well, to start with, all the proposals are prospective after these justices are done serving. That won't bring us change with regard to the current composition of the court. Also, I think that term limits are a really good idea. Life expectancy today is thankfully much longer than it was in 1787 when the Constitution was written. In 1787, the average life expectancy was 36 years. Clarence Thomas was 47 when he was confirmed for the Supreme Court in 1991. If he remains on the bench until he's 90, the age was Justice Stevens retired, Thomas will be a justice for 47 years. So this does not sound ideological. If Barrett stays until she's 90, that'll be 42 years. If Kagan stays until she's 90, that'll be 40 years. That's too much power in a single person's hands for too long a period of time. Too much now depends on the accident history when vacancies occur. Richard Nixon got to fill 4 seats in 2 years. Donald Trump got to fill 3 seats in 4 years. Jimmy Carter had no vacancies to fill in his 4 years, and Barack Obama had just 2 picks in 8 years. I think 18-year non-renewable terms would solve that. But I think it would take a constitutional amendment to create term limits for Supreme Court justices. Article 3, Section 1 says they have life tenure. Their seats so long as they have good behavior. And though I think there's people both on the left and the right who want to see term limits, I don't think there's a constituency that cares enough to do the work to get a constitutional amendment adopted in Congress and ratified by the states.
Okay, next question. Given Scalia's sense of how difficult it is to figure out what is a sincerely held religious belief, but with a court moving toward giving as much leeway to religion as possible, what will happen with COVID cases that are likely to arise where people seek exemptions from mandatory COVID vaccinations in order to hold employment of various sorts? Will those rules be struck down, et cetera, et cetera?
Let me start with current law. There is nothing in current law that requires government institutions or private employers to give a religious exception with regard to vaccination. With regard to the Constitution, remember, Employment Division versus Smith says it's a law that applies to everyone. There's no religious exemptions. And Employment versus Smith is still the law. So the University of California is giving a religious exemption from vaccination. It doesn't have to do so. Also, with regard to federal employment discrimination law on the ground of religion, the Supreme Court said that there's no violation of federal employment discrimination law so long as accommodating religion would put more than a minimal burden on the employer. Well, allowing people to unvaccinated would certainly cause more than a minimal burden on the employer. So I don't think that there has to be any religious exception to vaccination. In fact, several states, including California, require children to be vaccinated against a whole host of communicable diseases, and they give no religious exception. And challenge to that, it failed. At Indiana University in Bloomington, there's a vaccine mandate, and some students brought a challenge to that. They lost in the district court, they lost in the Court of Appeals, and Amy Coney Barrett refused to give relief. She's the justice for that part of the country. So maybe the court will change the law and protect a free exercise right to not be vaccinated. On the other hand, under current law, it's so clear that there is no free exercise of religion right to choose not to be vaccinated.
Next question. Given the current Supreme Court composition, is there anything that can be done to protect voting rights and a woman's right to choose?
I think we have to look to other than the Supreme Court. With regard to voting rights, several bills have been introduced into Congress. A couple of introduced earlier, and then one just introduced a week ago by Senator Amy Klobuchar. And what we need to do is pressure the Senate to pass these voting rights bills. The difficulty is the Republican filibuster, and that so far Senator Joe Manchin has refused to be willing to change the filibuster. But if we're going to protect voting rights, it's going to take federal legislation. With regard to abortion rights, There certainly is a possibility there too of federal legislation, but it faces the same problem, a Republican filibuster in the Senate, and a willingness of a couple of Senate Democrats to change the filibuster. So my answer to your question is the only way to protect voting rights or abortion rights nationally is going to be through Congress, and to do that is going to require modifying the filibuster.
Thank you. Next question. What do you think this current court's use of the shadow docket will do in relationship to the respect that the court has among the American public?
As I said, the shadow docket is when matters come to the Supreme Court for emergency rulings, an emergency request for an injunction, an emergency request to lift an injunction. And the Supreme Court issues a ruling without briefing and oral argument. There are some law professors, William Bow at the University of Chicago, Stephen Vladeck at the University of Texas, who have documented a tremendous increase in the use of the shadow docket by the Supreme Court. But the question is about the legitimacy of the Supreme Court. And I don't know. I mean, I'm always reluctant to talk about legitimacy because I don't know exactly what it means or how it's measured. If it's opinion polls, a recent Quinnipiac poll showed that the Supreme Court's esteem level of American people was as low as it's ever been. So perhaps what the Supreme Court is doing is reducing its credibility. But the reality, the credibility of the Supreme Court or of any institution is built up over a long period of time. What will cause it to decrease? How permanent will the decrease be? What would be the effects of the decrease? It's just impossible to know at this point.
Thank you. Do you agree with historian Michael Beckloss's comment that democracy is hanging on by a thread?
I agree that our democracy is in grave danger. I agree that we faced between November and January 6th, the greatest threat to American democracy that we've seen, and that's not hyperbole. Never before have we seen a president of the United States, in an effort to stay in office, try to stage a coup. I'm sure you've followed the news from this week, the new book by Bob Woodward that has shocking revelations, the articles such as the front page of the New York Times that the Trump campaign knew all along there was no evidence of fraud. I was particularly dismayed to see a memo. It's in peril. You can find it on CNN.com or any sort of, written by a former law professor at Chapman Law School, John Eastman, who in 6 points outlined how Mike Pence could give the election to Donald Trump, notwithstanding the votes. Our democracy could have so easily ended. What if election officials in Georgia and Michigan and Pennsylvania caved in to President Trump's pressure? What if the Michigan or the Pennsylvania legislatures gave their electors to Donald Trump, notwithstanding the popular vote? What if Mike Pence, who at that point had been such a loyal Trump lieutenant, had said that he was going to give the election to Trump in just the way that John Eastman allowed? We would no longer be a democracy. The threat to democracy is so great right now. I think the Electoral College is a threat to democracy. Twice in this century, the candidate who lost the popular vote became president. And it almost happened 2 other times. Had 49,000 votes been different last November in 3 states, Donald Trump would have been president despite losing popular election by 7 million votes. Our country is so deeply polarized. That too is a real threat to democracy. So is it hanging by a thread? That might be hyperbole for me. Is it in trouble and we face great dangers? Yes.
Thank you. What legal steps could be taken to prosecute Trump for his conduct in regards to January 6th? Is there anything that can be done about it?
Yes, the United States Department of Justice could indict and prosecute Trump for incitement of illegal activity. There's also certainly the possibility that the attorney for the District of Columbia could prosecute Trump for that. There's the possibility that other states could prosecute Trump for his conduct. There's an investigation going on in Georgia as to whether Trump impermissibly tried to alter the outcome of the election. So there's certainly the possibility of prosecution. My guess is that the Biden administration has decided that a criminal prosecution of Trump would do more harm than provide benefits, and that they want to just move beyond this, but we'll see. To this point, no prosecutor seems to want to come forward and prosecute Trump with regard to anything concerning January 6th or what led up to it, though there are indictments of Trump's businesses in New York.
Thank you. Now we get to Justice Breyer. Do you have any predictions? Do you think he will step down? Do you think his replacement Biden should be doing before 2022? Any comments on what you would like to see?
Sure. In March 2014, I wrote an op-ed in the LA Times urging Justice Ruth Bader Ginsburg to step down that summer. I said it looked like the Republicans were going to take the Senate in November 2014. They did. I said there's no way to know what's going to happen in the 2016 presidential election. A tremendous understatement. I said if Justice Ginsburg wants someone with her values and views to take her place, now is the time for her to retire when there's a Democratic president and a Democratic Senate. Because realistically, in the summer of 2014, President Obama could have nominated anyone and the Senate was going to confirm. I never imagined that Justice Ginsburg would care what a law school professor, law school dean in Southern California was saying, but she was very angry at my op-ed. She made sure that people we know in common called me to express her great displeasure. I received a huge amount of hate mail. Some who usually agree with me, like Dahlia Lithwick, strongly disagreed on this. Justice Ginsburg repeatedly gave interviews where she said, some like Erwin Chemerinsky think I should step down. No one can do the job as well as I can, and I'm not going anywhere. She gambled. We lost. Her place is taken by somebody who's as far to the right as Justice Ginsburg was to the left. So this spring, I wrote an op-ed in the Washington Post urging Justice Breyer to step down at the end of the term. So there's a Democratic president and a Democratic-controlled Senate. But keep in mind, just barely, there are a number of states that have Democratic senators, but Republican governors. Take, for example, Patrick Leahy from Vermont. He's 87 years old. If he were to leave the Senate, he'd be replaced by a Republican governor, Bernie Sanders, same situation. It only takes replacing one Democrat with a Republican to give Republicans control of the Senate. And I said, in that case, no one President Biden nominates is going to get confirmed by Mitch McConnell in the Republican Senate. Well, Breyer didn't retire at the end of June or the summer of 2021. The justices return next week to work and in 10 days to oral arguments. So Breyer's not going anywhere now. My prediction is that at the end of next June is when he'll retire. And that way there'll be a confirmation of his replacement in the summer of 2022 before the November 2022 midterm elections. But that's just a prediction. Certainly no more information than anybody else. It's interesting though that my op-ed urging Breyer to retire didn't get hate mail, didn't really get much mail at all. And certainly it didn't engender the same kind of reaction as saying that about Ginsburg. I think some of that is that Ginsburg was a popular icon in a way that Breyer's not. I think some of it also is, perhaps we all learned a lesson from Ginsburg not stepping down and the result ending up with Barrett.
A question, could you give us a brief history of the current Roberts courts preference or favoring of business over labor?
Yes, this is a court that is very pro-business and very anti-labor. Let me give you some recent examples. There was a Supreme Court decision in June of this year, Cedar Point Nursery versus a seed. It involves a California law that requires that agricultural employers allow union organizers to have access to workers 3 hours a day, 140 days a year. It has to be before or after work. It can't disrupt work. There has to be notice given. The Supreme Court said this is an unconstitutional taking of property from the agricultural employers because you're allowing access onto their property. Chief Justice Roberts wrote, joined by Thomas Alito, Gorsuch, Kavanaugh, and Barrett. Justice Breyer wrote the dissent, joined by Justices Sotomayor and Kagan. Justice Breyer said, this isn't taking anybody's property. The owners still have title. This is just temporarily allowing people onto the property. Or another example from 3 years ago, a case called Janus versus American Federation. In 1977, in a Abood versus Detroit Board of Education, the Supreme Court said that a state can require that non-union members pay the share of the union dues that go to support the collective bargaining of the union. The court said non-union members benefit from collective bargaining. They can be required to pay their fair share of the dues, but they can't be forced to pay the share of the dues that go to support the political activities of the union. The end of June of 2018, the Supreme Court 5-4 declared such laws unconstitutional. The Supreme Court said that the government can't require people to pay even the share of the union dues that go to support collective bargaining. The court overruled the over 40-year-old precedent. I give many other examples, but the Supreme Court consistently has favored businesses over workers, and it's consistently been very hostile to unions.
Thank you. Next question. Is there any answer to the dilemma of the Electoral College? Is there an answer that's something that could be done?
Not that I've ever seen or heard that's realistic. We could amend the Constitution to eliminate the Electoral College, but the reality is to amend the Constitution takes 2/3 approval of both houses of Congress and 3/4 approval of the states. And the states that benefit from the Electoral College aren't going to vote to change it. In theory, a court could declare the Electoral College unconstitutional. And though that might seem strange, the Constitution's amendments certainly amend its text. The amendments ensure equal protection, and that therefore is violated by the Electoral College. But no court is going to say the Electoral College has existed since 1787, that's written into the Constitution, is unconstitutional. There's a proposal for a national popular vote compact. It's a really clever idea. You get all the states, or at least enough of them, to sign that they promise they will give their electors to whichever candidate gets the most popular votes. Well, there's some real problems with that, though. Only blue states have signed on. No red states have, which means it wouldn't work. But beyond that, it's not enforceable. Imagine a situation where Texas voters go for Trump. And if Texas gives electoral votes to Trump, he becomes president. But the popular vote went for Biden. Do you really think that Texas will decide the election for Biden just because of a compact it signed? So no, I'm very familiar with the literature. I don't see a solution to the Electoral College.
On that depressing note, we'll move on to another question. Could Brett Kavanaugh be recalled if it is determined that he actually did lie during his confirmation?
There's no such thing as a recall for a Supreme Court justice or for the president or vice president or any federal judge. There is the possibility of impeachment and then conviction in the Senate. A person can be impeached for treason, bribery, or other high crimes and misdemeanors. If a majority of the House were to vote that, the person's impeached. If 2/3 of the Senate votes to convict, the person is removed. But I don't see any likelihood that there's going to be a serious effort to impeach and remove Brett Kavanaugh, even if it's proved that he lied. After all, Clarence Thomas, I think, unquestionably lied at the Anita Hill hearings almost exactly 30 years ago in October 1991. Lest you think I'm making this up, I encourage you to read a book by Jill Abramson and Jane Mayer, Strange Justice, that really documents how Thomas lied. But Thomas is now 30 years on the Supreme Court. He's not going to be removed. So the only way would be impeachment removal, and it's not going to happen.
And given your time limit, I think this may be our last question.
Okay.
How do you think Roberts will deal with being the Chief Justice of such a polarized, politicized court?
I think Roberts cares a great deal about the institutional legitimacy of the court. And I think that Roberts is someone who, because of that, would not want to go as far as fast as some of his most conservative colleagues. I think one of the important things about what happened 3 weeks ago in the Supreme Court, to go to Texas abortion law, is that Roberts lost his court. Roberts dissented along with Breyer, Senator, and Kagan. The 5 conservatives here, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, didn't need Roberts' vote. Before Justice Ginsburg died, the Supreme Court had 4 conservatives, Thomas, Alito, Gorsuch, and Kavanaugh, and 4 liberals, Ginsburg, Breyer, Senator, and Kagan. Roberts was squarely in the middle. He was the swing justice. That last year, Justice Ginsburg was on the court. Roberts was in the majority more than any other justice. But now no longer is Roberts the swing justice. There are 5 justices more conservative than he is. And so I think if he's going to steer the court to a more moderate course, it's going to be far, far more difficult.
Dean Chemerinsky, thank you very, very much for joining us today. I know that you have another event to go to right after this one. So we appreciate your joining us, and we hope you will come back next year.
I'd
I'm
love
definitely
to.
sending you a letter pretty soon.
Thank you. Thanks for having me. Truly a pleasure. Thanks for all the wonderful questions. Bye-bye.
Okay. For the rest of the people on the colloquium at the moment, I want to remind you that next month, via Zoom on October the 21st, the colloquium will present author Lisa Napoli. She will speak on how we became a world of news junkies. Don't miss it. Her 2 most recent books are Susan, Linda, Nina, and Koki, The Extraordinary Story of the Founding Mothers of NPR, and Up All Night, Ted Turner, CNN, and the Birth of the 24-Hour News. So please do come back and join us in a month. Thank you to all.